What happens when law, business, and life collide? Each week on Lead Counsel, your host Tom Tona will take a deep dive into topics related to the law, the business of law, and life. There will be insightful discussions with industry insiders, experts, and thought leaders making significant contributions and meaningful differences in their fields of expertise. Tom is the founder and managing attorney at TonaLaw. He has been a practicing attorney since 1994 and the leader of TonaLaw since it opened in 2001. The goal of this podcast is to provide you with free information on law and the business of law, and to give you actionable tools related to each of these areas. Now, here's Tom.
Hey, welcome back to the Lead Counsel Podcast. Your host, Tom Tona. Before we jump into today's topic, I just want to take a minute to thank the sponsors of the podcast. This episode is sponsored by TonaLaw. They're not just another law firm. They're defining what it means to fight for their clients. We get a lot of attorney referrals from across the country. We pay fee participation in all jurisdictions where it's permitted. We focus on integrity, innovation, and relentless advocacy. TonaLaw is proving that the business of law can scale without losing its heart. If you want to see how a modern firm is built for impact and happy client referrals, check out TonaLaw.com. Mention again the Lead Counsel Podcast, and I'm happy to get on the phone with you. My special guest is a good friend of mine, Michelle Fuller. Michelle and I are part of a closed mastermind, and she's the founder of Michigan Law Center and Advocacy. Recently, after knowing Michelle almost a year at this point, I got to sit down and say, Michelle, what do you do? Like I've never been able to figure out. So she broke it down for me in the simplest terms, because I'm not that bright a lot of times. And she broke it down, and it was like really super intuitive what she was explaining to me. Michelle works with and is a nationally recognized expert in settlement planning, particularly for clients with disabilities. She works on a lot of large bodily injury cases and mass tort cases. So I think it's really pertinent and timely to discuss this now. A lot of plaintiffs' attorneys listen to this. So Michelle, welcome. How are you?
Great. It's great to be here.
So you're going to explain what you do in layman terms, in the simplest terms, so we get what you do.
So for the law firm, there's two areas of liability. The first is when the law firm accepts the funds from the defendant. And the second area of danger is what we call the danger zone, is when the firm distributes the money to the client. And so my focus is on making sure that the firm is protected, because they strategize so much on trial work and how to win the case and how to get the most money that they can for the client. So what I'm finding it's missing is strategy around the end of the case. And that's where things get blown up, right? Mm-hmm. So how do we protect the firm from liability, from accepting the money? And then any kind of liability for minors or people with disabilities when they're distributing the money to the client. So how do we protect the client? Make sure that their government benefits remain in place if they're on government benefits, and we prevent the lottery effect. So even people that are typical people that don't have any known challenges other than maybe they just haven't had the opportunity to manage millions of dollars, you don't want them calling you a year later or 2 years later saying, my life sucks. Can you get any more money for me? And so that happens a lot. I hear about that a lot. And so what I focus on is protecting the firm and protecting the client, making sure that the money lasts as long as possible for them. It actually makes their life better. And so it's a strategic advantage for these great plaintiff firms that actually care about their clients and the lives that they live after the case is done. So that's what I focus on.
So you focus your work, and I know you focus yourself on maximizing independence for the client, right? The disabled client specifically. And then when you talk about public and private resources, so talk about a client who is going to be on disability. Client is mid-30s, and he gets a settlement of, $500,000 rather than what has been done in the past where the PI firm takes in the $500,000. They do the Medicare set aside. Client says, I'll put aside the money. Now the future benefits are taken care of, protected, and the liens get negotiated and then paid off as well. So the past benefits are taken care of and everything's done by the book. Rather than doing that, what could they have done with you?
So A lot of times let's say it's a medical malpractice case. If that's the case, then the dollars would typically be a little higher.
Yes.
But so let's say that there's, in this case, the scenario, you've got your 30-year-old and you've got multiple defendants. Okay. And you've got, like you said, you've got some complexity around this client is applying for disability because they can no longer work. Okay. So then where I come in, hopefully, is earlier the better. So you've got strategies on maximizing the recovery for the client. That's what a good litigator will do, right? They're worried about depositions and calling in experts and all that kind of stuff. So that's great. But where I come in is like, okay, we're talking about mediation and they're talking about bringing in collateral sources, meaning who can offset the defendant's liability? Are they allowed to bring that in? They're talking about structures. You're talking about a special needs trust. What's going on here? Okay, so I can help with that because you guys litigate. You don't know this part of the law, nor should you. It's okay.
Right.
So I can help with that. But you're planning for the end of the case earlier. There's a strategy involved. And so, okay, how do we know what we're doing financially for the client? Well, we don't know until we know exactly how much we're going to recover for them. And so that's where I might look at a case with a qualified settlement fund. So you can settle with each defendant and put it in a neutral holding tank. You're not holding it in your IOLTA. There's so many reasons not to put money in your IOLTA. We can have that as a separate thing about, we can talk about qualified settlement funds. But that's one advanced strategy that I think is completely underused by litigation firms, because then you're not handling multiple millions of dollars in your firm.
Operationally, once you're in play, you're coming in, you say, okay, when and if the case settles or you get a verdict, here's what we're going to do. Do not send releases out. We have to get certain things documented. So the check is going to go to who?
Exactly. So the bigger the case, the earlier you want your expert, someone like me who knows settlement planning, who knows how to plan for the end of the case, the earlier you want them involved. Why? Because I have other resources. So if you're grappling with, like I said, about like mediation, people are throwing out stuff. They're like, what the heck are they talking about? You have a resource. Or you're looking at their proposed life care plan for a brain injured client. You're like, no, this isn't big enough. Where's your expert? Okay, I've got experts I can bring in. I don't do that part, but I know some really good people to bring in. Okay, fine. You're looking at an allocation for a Medicare set-aside account. You're like, this is really out of whack. I don't do that. I know enough to make me dangerous, but I do have experts that I can bring in and add to the team of experts that might be needed, from tax advice to benefits coordination, life care planning. So really, I'm kind of like your key your offensive coordinator on the sidelines going, okay, we need special teams brought in. Who's our expert to help manage that part? So the bigger the case, the earlier on you need that. And so they might be talking about, there might be a strategic advantage that you don't know what you don't know, right? And so You've got your planning aspect, and then you've got your brain injured client. And the idea is to coordinate with them. Do they have capacity? Who's signing the release? Right. So that's a huge area of liability. I know, and you know, plaintiff firms, they don't want any slippage, right? They don't want anything to slow down the case. Okay. So part of the strategy involved is, do you have to go to probate court?
For an Article 81 or something, right? In New York, it'd be Article 81, I think.
Yeah, exactly. Who has authority to advocate for this person? So you want your release to be solid, right? How it's paid out. Are there advanced techniques? Are there advanced things? You don't have to know what a QSF is. I need to know, okay, I'm going to recommend this tool because of this. And so I will just bring together a strategy that will help hopefully mitigate liability for the firm, make things quick and easy.
So you basically act as a settlement consultant planner, right? And I want to see if I get this straight. So, okay, I got a case that settles. It's in the book. The client's agreed to the number. We're aware of any outstanding liens. There may be some out there still. My question would be this. What instrument would you use so that the funds aren't going into IOLA? Is it compliant with all the ethical rules that are out there? One. And two, so once the funds are received, whatever company, I guess they're held in some kind of trust, right? It's going into some kind of trust. And then that trust will hold the client's money until Zip Liens releases all the liens or gets all the liens released. Yes?
Yes.
Okay. Then what's remaining will get disposed of in whatever way you and the client agree is the best way for that to happen. It might be held in trust with an annuity paying out XYZ or whatever it is.
Yeah. So the tool that I use is a qualified settlement fund. I've written articles about this. They're pretty, they've been around for several decades now. So what it is a neutral holding tank. It's a trust that's developed under the Internal Revenue Service rules. And so it's a tax trust. So instead of you taking into your client trust account, into your firm, you've said you have lots of processes around this. And I personally know
it makes me nuts. It makes me nuts. Yeah.
They had long-term employees embezzle funds from their client trust account. We've heard colleagues in Atticus that have had partners that have taken money inappropriately. There's only so much you can control. Process is you can't out-process this if you are handling that money.
Right.
And so having it external, a trust company. So there's bank trust departments that do this. I use a variety of people. One of my favorite providers is Eastern Point Trust, and they've got all kinds of information on their website about it. They've really innovated in this space and made it accessible. It takes about 15 minutes and less than $500 to set it up. So quick and easy button, right? I like that. But what I love about that is that you can settle with each defendant. Like some defendants will pony up right away, right? Depending on liability, they'll max out on their policy limits. Here you go. They want out. Okay, great. You don't want to hold that money for that long.
Right.
Is it FDIC insured? You've got exposure in the firm. You've got all these, how many hours are dedicated to managing that money between bookkeeping and making sure the proper authorization, who's authorizing this money, where does it go? And the other things for the client, once it's received by the firm, it's constructively received by the client. You've received it on their behalf. And so the technical rule is that if they are on government benefits, they've received that money, even though they don't have control over it. So that's a problem. So
yes.
If you're on Medicaid, SSI, and if you're holding on to it while you're, negotiating with other defendants, that could be a problem. And so if you're putting it in this neutral holding tank, nobody receives any income from that. And so you can settle with each defendant. It buys you time. It also gets the defendant out. They're gone. They're done. You don't have to deal with them anymore. And then you get a full financial picture. So there's planning opportunities. I know we've talked about this in our Avengers group, right?
Right.
So before the law firm receives, let's say it's a great monster case, right? Or you typically do monster cases. God, I hope you do. But if you do a brain injury cases, we're doing this podcast in October. What's your ability to do tax planning before you receive this massive amount of income? Are you paying more taxes than you should? If it's in a QSF, you can take your time and make that. There's no great rush. You can do your tax plan. You choose when to take that income.
Wait, hold on, pause on that. So if you're a personal injury firm, it goes into the QSF. So let's say for a second, it's $1 million legal fee for a second. God bless anybody that gets those, and they're awesome. So $1 million legal fee goes into the QSF. Let's say it's a $3 million settlement, $1 million legal fee for ease of math. Yep. It goes in on October or November 1st. Let's say November 1st.
Right.
You're either going to pay a massive amount of taxes north of like $450,000 most likely, or close to $500,000, or you're going to get the call from your accountant and start spending money down on legit business expenses, or like some firms with those mass tort settlements, they actually will pre-plan advertising. But using a QSF, you're saying you can then plan out the distribution of the legal fees in a tax advantageous way, and it passes muster with the IRS, and it's not taxable till you're drawing the money in the way it's laid out.
100% spot on.
One of the questions that I know several of the plaintiff's attorneys in the room voiced was, look, I love the idea of this, but I just have clients that are not going to XYZ. So let's say you get that $300,000 settlement. The legal fee is going to be $100. Let's call it, for ease of use, $200 is going to go to the client, right? We know there's disbursements, but we'll zero those out for a second. $200 is going to go to the client. How are you explaining to the client, listen, you've got benefits you're going to impact if you take it, and we can still give you money. We just have to allocate it properly. Tell me what you need. You need a new car? Tell me how much you need. And then we put the rest in the QSF. And what happens to that money in the QSF? It's earning a rate of interest, I'm assuming. Is it an annuity product? Like, where are they investing it?
It's a great question. So when you have a qualified settlement fund, the client can still structure, if that's part of the equation.
Right.
Out of that, where normally it has to be purchased by the defendant. It can also be purchased out of a qualified settlement fund because there's no constructive receipt. Okay. So what I like about that is that you can settle up with all defendants involved, get a full financial picture so that you know how much, if any, to structure. What's a sound financial picture for that client? And then I love using a trust. So if it's a minor and they're receiving a fairly significant amount of funds, I don't want them spending it all when they're 18. Right. And so I think you kind of nailed it, where the way that you talk to clients about this is not necessarily a disadvantage. So one of the worst things we can talk about is like, hey, yeah, you got this great settlement, but you're on SSI, so you can't own or control this money. All they hear is loss of control.
Right.
And so what I talk about first is, what are they afraid of? What is their biggest concern? Is it loss of control? Is it loss of benefits? I'm going to lose my income. I'm going to lose my health insurance. I'm going to lose my Section 8 benefits. So what's their biggest fear? What are they most concerned about? And, clients with mental health issues, I think, experience, and, what is their underlying disability? It may not have anything to do with the case that you're litigating, right? So I'm listening for things that your intake is not listening for, right? Because I'm looking at, how does this client's profile or their particular circumstances impact how they're should receive this money? What's their best outcome? What does that look like? And so, like you said, what are their unmet needs? Are they driving a jalopy? Are they couch surfing because they don't have a stable home? It just depends. And then sometimes we've got families that are highly educated, highly sophisticated, and it's a birth trauma. And so the conversations, you have to meet the client where they're at, and they may have different concerns. And so for a client, let's say, so there's different trust products, right? I like using a pooled special needs trust for smaller settlements. Anything under $300,000 to me is a no-brainer that should go into a pooled trust. Why? Because I'm not doing drafting. You've got a professional trustee. The worst thing that you can do as a planner is have a family member in charge of someone else's money, in my opinion. They already have enough jobs to do. And this is another job that you're handing them.
Yeah.
Plus,
and it's a burden. It's a real burden.
It's a burden for everyone, because if you're giving some family member another job to do, and then you're having this beneficiary, whatever their age is, ask a family member for money. It's a terrible idea.
Yeah, it's a bad dynamic too.
It really is. It infringes on it. And there's a lot of errors there. And if the person is really disabled, like they have a brain injury, or they're, not able to advocate for themselves, who's looking over these people's shoulders? It's just setting the client up for success. To me, best practices is checks and balances, whatever that looks like, right? And so I like a pooled trust for that.
Quick break to thank the sponsors of the podcast. This episode is supported by TonaLaw, a modern law firm built on integrity and innovation. Learn how they're changing the game at TonaLaw.com. Attorney referrals accepted from across the country. You'll see what it's like when you send us a case. You'll have some happy clients. So you mentioned an MSA before. Now, I'm familiar with a lot of this stuff because I've had to, as the cases have gotten larger in my office, we're seeing a need for certain post-settlement strategy that, we had a larger settlement come down first quarter last year. And the attorney that was trying the case, who's an excellent trialist, was like, listen, you're going to need an MSA on this, right? And I'm MSA. So you mentioned it earlier. Explain for anybody that's listening to this as if they were me, what an MSA is and, the current state of MSAs. Is it changing under the new federal laws that are coming down seemingly every day, that type of thing?
Sure. So an MSA stands for Medicare Set Aside, and that's a type of account. So I think all trial lawyers are aware of liens, right? So someone gets injured, they receive medical treatment to help, with whatever caused the injury, to get someone better. And then if they bring a lawsuit recovery and they do recover and medical expenses is part of that, then whoever has provided the medical services gets reimbursed. So those are conditional payments. Everybody, I think, knows that piece of things. But where there's a Section 111 under the Medicare, I forgot the name of the Medicare savings. Anyway, there was legislation, I can't remember. Right. But that tried to help Medicare and prevent people from basically double dipping. So if you get compensated for future medicals and the person is on Medicare, you can't get your Medicare services paid for and have a financial recovery for that. So that makes sense from a logic standpoint that you can't double dip is what that essentially means. Medicare Secondary Payer Act, that's what it was.
Right.
So that basically means that somebody's been injured, they've received medical treatment, they've gotten compensation. Now, before you can completely wind up the case, if the person's on Medicare, you have to estimate forward what future medical treatment they might need that Medicare would cover and set that money aside. So what impacts that? What their condition is. You have to have the right ICD-9s and 10 codes to look at review and future treatment plans. So that is not me. There are specialists. That's all that they do. God bless them, is look at, medical codes. They look at past medicals, what the person's condition is, what they might need in the future, and they estimate forward. Do you have to have a perfect crystal ball? No. Where this comes into play, and I see it most often, is in the workers' comp field. That is mandatory, where you have to have one. If someone's on Medicare, you have to do a Medicaid or Medicare set aside in that case. And it's for a very low threshold. So almost all my workers' comp cases have Medicare as part part of the redemption orders. Yeah. So the tricky piece of that is that under the federal POMs, or the federal policy programs, that Medicare set-aside account that can only be used for medical treatment is a countable resource for someone who's on Medicaid. It's countable. Now, under our state policy, it is not. Under the federal, it is. So it becomes a little more complicated, right? Where people have got this whole mishmash of stuff going on as far as like benefits, what kind of Social Security, what kind of healthcare benefits. And so that's where the 911 call is like, hey, Michelle, what do I need here? Right? How do I set this up?
Right.
And that's fine. So that's where you need that all the time. Workers' comp, those attorneys, everybody knows MSAs, structured settlement brokers are really great in that context. Oh my gosh, they are a huge lifesaver. MSAs funded by a structure are fabulous. Now, who determines how much is set aside?
Before you even get there, in the third party context, how do you determine when or when not? Because I've heard really bad advice from lawyers, companies that do it. And like, I want you to set the record straight, barring any change in the law as it exists today. How do you know when, as a third party liability attorney, you need to inquire with an MSA provider?
Okay. So when it comes to MSAs and liability cases, what do we know is true? Is that there is no statutory mandate to create an MSA or Medicare set aside in any liability cases. And in all of the legislation that has come through recently in the big, beautiful bill, there's nothing that affects that. There's no mention of it. There's no impact there. And so clearly the rules are the rules where you can follow the rules. However, there are some things that you can do to help protect your firm from future liability. So there is huge civil penalties for failing to protect Medicare's future interests. So what does that mean for you as a practitioner to bulletproof, at least as much as we can, your settlements, your resolution of cases that involve especially catastrophic cases? So are we that worried about like a small auto case where there's somebody's on Medicare and they're getting a third party resolution? No, not really. Where we're concerned is where someone has a catastrophic injury and they're on Medicare or in the application process. So where does that come into play from a benefit standpoint? Somebody who is on SSD, Social Security disability, and they have Medicare either pending or they already receive it. Now, the fun part is that when you ask clients, they won't know what they have. So this is where logging in, there's all kinds of professional organizations that will check and confirm like status of liens, whether somebody is enrolled, and what kind of Medicare coverage they have. Now, to keep it fun, there's kind of hundreds of different providers. And so this is where professionals that do this all day long are really key to add as a resource to the settlement team. So the long and the short of it is it's not required. But again, where we have future medicals, let's say somebody is catastrophically injured and they have 24-hour care provided in a skilled nursing facility. And they're like on a vent or something horrific where they need skilled care. So future Medicare coverage is going to be key in that case. So the worst possible outcome is that at some point, Medicare shakes their finger and says, oh, you should have taken into account our prior, our liability, our future interests. You didn't to an adequate standpoint. So even if you do an MSA, are you going to get some sort of letter saying that you've adequately protected Medicare's future interests from the Center for Medicare and Medicaid Services or CMS? Nope, it doesn't. You're not going to get anyone they won't even look at them. Right. So all you can do is document your file. So if you have somebody who is, and this is fairly typical, somebody has gotten as far as they can, like as far as accident or injury related, incident related services, they're done. Get a letter from a doctor, paper your file. You may not need it, but you'll want it 10 years from now if somebody ever comes back to audit your files at any point. It's just about papering.
But it also sounds like there might be what you can do and there might be best practices. So if you have a settlement above a certain threshold, let's say 500,000, maybe even that's too aggressive, right? Let's say 350, whatever number you would pick.
I'm thinking large medical malpractice, multi-million dollar
Okay.
recovery with somebody who has clearly on Medicare and will have a substantial need for Medicare services in the future. I think that's where it's worth at least investigating and doing a perspective, a possible allocation. And then this is where, like I pull in service providers like National Care Advisors or a Massive. There's different lien res companies that are really experts in looking at those allocations to get them down as small as you can. So I've also seen a couple of things where that can be interesting on a settlement perspective. So sometimes having a really healthy set aside, or that you estimate that the liens are going to be really high, can help facilitate a higher number because
we always use them. Yeah.
It's a strategy. It's a trial technique to help make sure that you are leveraging every aspect of your client's case to get the highest possible recovery. And then afterwards, once you get that, you kind of go, okay, now let's look at this allocation and make sure that we have the smallest number possible.
Right. Understood. And I think everybody knows that, right? Like you want to optimize what you're doing with the leverage on it, but then you're going to do everything you can to say, look, what's the realistic need for that set aside, right?
To be perfectly frank, I think that in my practice, what I see as a settlement planner is that I have not seen aggressive MSA set asides even for catastrophic claims because there's no rules. So if the number is, say, small enough where it really will impact the client, get their buy-in and say, hey, this is just a protective measure. It's not required, and get their buy-in. And if it's a small number, it really doesn't make much difference, then maybe err on the side of protectiveness, right, to do that. If someone's looking at future Medicaid eligibility, though, it's going to be really important to make sure that that MSA is not self-administered, which I've never seen go well.
Right.
I haven't. Now, have I seen any fallout from that? Not really, not in my practice, but is it possible? Yes. But I usually like to have those things owned by the special needs trust, right? That just puts a layer of protection. It's just another layer of administration that I like pulling in a professional to do because I don't sit there looking at ICD 9s and 10s. And because when they're paying out of that account, there's different levels of reimbursement. So the level of reimbursement under a workers' comp claim by a provider might be different than that as a Medicare provider. And you have to know which one. And also negotiate those prospective liens down or prospective costs down because, are you going to pay $5,000 for an MRI or $500?
Right.
So that's where, some providers will do it for free. Others will charge a fee. But the biggest thing to know is that a structure is a great way to fund it because instead of, let's say it's a workers' comp claim and we have to do one and it's a large injury and we have a $200,000 set aside because this person has catastrophic claims and Medicare is on the hook. Fine. So is it better to take $200,000 as a lump sum out of their recovery or have that buy a stream of income that will pay it out over their lifetime?
Right. An annuity, basically.
An annuity. A structured settlement is annuity. So just another little piece of the things is that if the Medicare set-aside provider who's going to administer that charges a fee that cannot get paid out of the account, you have to have a separate structure that pays their fee. So I think one of the higher fees that I've seen is $1,500 a year. It's a very small little structure that pays $1,500 a year that directly to the provider. So, but it's setting it up from the start, knowing that that has to happen that way. So you don't want to make sure that you're leaving a provider high and dry, where you've got the right team in place from the structure broker, the analysis of the allocation, whether you even have to do one in the first place, whether it makes sense. And this is where, as a trial lawyer, my job, so I like to call myself a settlement architect. I'm not selling financial products. I'm helping to architect a settlement that will help protect you as an attorney and make you a rock star for your client because the funds that you have fought for will actually make a difference to them in the long term. So that's what that's all about, is really setting up your team of experts that you can rely on to make sure that you can, one, know that it's being taken care of, and then two, you're going to go on to your next case.
Right. And you don't have to look back. You don't have to now pull the digital file and start combing through and reconstructing everything that happened.
Yeah.
Look, I'm very aware of it, and I've just tried to employ best practices since talking to you where, if there's an open question, I'll just text you or call you and say, hey, Michelle, I just give me the skinny on what you see here, what you think is needed. But again, I do think it's helpful because even if it's a small PI practice, occasionally they'll have the one big case they land and it comes down. And then the last thing you want is to drop it at the last end zone of the case where you've already got the money coming in and you haven't really structured it properly for the client. There's a new generation of practices popping up every day. And so hopefully they hear this and they go, oh, when I get that big case settlement, I got some work to do. I call Michelle, somebody like Michelle, and really dig down on what I need to employ. We had a brain damage case where there was a large policy, very large. There was layers. There was a tower of coverage and there was a tender of all the money. And, I tried explaining to the family, like, look, you need some help. This was before I even knew you. And I called in an estate planning attorney. Yeah. They recommended a special needs trust. So switch over to the business side. I know I've seen some of your marketing coming out with the ticking time bomb that's in settlements, right? So explain the concept again and where the special needs trust aspect of it comes in.
Yeah, I think that there are some things that you don't want as an attorney, which is ever to get a complaint because you didn't adequately advise your client as to the impact that their settlement would have on their benefits. And so it's a key area of potential liability for an attorney. And that sinking feeling that you should have done something that you didn't, or you screwed something up, is horrible because you've gone out, you worked your guts out, you have this team, you have all of this, and it's all about helping people and help recover from an injury or something that bad that happened to them. And then there's this fallout. So it can happen on small cases, it can happen on big cases. And so the impact is real. And so what we do at the Architected Settlement Law Group, so I want to be really clear, I give legal advice, I don't sell financial products. So you tell me about that case. And the first thing I'm thinking of is, how many defendants are there, right? There's a brain damage case. Are there multiple defendants? Are you settling separately with each insurance company? So the first thing I think of is a qualified settlement fund. How do you fully settle with each company? And then how do you resolve liens in that case? How do you know how much you're dealing with? When do you do the MSA? So it's all about timing. So how can I buy you time? Qualified settlement fund. So each one of those insurance companies that want to settle, you collect the policy limits and you put it in a QSF until all the claims have been dealt with. All the insurers are done. In the meantime, we've been gathering information on liens, right? And we make sure that we talk to the client that the gross settlement that they're looking at is not what they're going to take home, and make sure we prep them for the liens because the liens could eat up a significant portion of it. That's where the opportunity for more advocacy comes in by the litigation firm. And it doesn't necessarily have to be by you guys, right? The lead trial, because I look at you as a lead trial lawyer, a lead trial firm. And so that might be where you bring in a lit pro, a lien res company that goes in and you might need to advocate. And I will tell you one of the impacts of this big, beautiful bill. There's nothing in there about Medicare Secondary Payer Act. There's no revisions to the reporting or CMS. But what we do see is reduced budgets for state Medicaid funding. So that means you're going to see higher liens. You're going to see more aggressive state recovery.
I was going to say at the state level then, got to get the money from somewhere.
100%. And they're going to be a lot less willing to negotiate. And so this is something to really be clear on as to what number, because everybody's got kind of a number in their mind as to what the client will net. And so in a case like a brain injury where you've got, or any catastrophic injury where you have a life care plan, what will this client need? Now there's life care plans that you need for litigation, right? To really make sure they're advocating for your client, every possible resource out there.
Right.
But in reality, what are they really going to need to make sure that they're not going to be made whole, but that they have a reasonable life expectancy and a reasonable quality of life? You need to get to that number somehow. And so you're going to have to reverse engineer it, and that it will drive numbers up.
Right.
Clients' out-of-pocket costs are going to go up. You're going to see less coverage, long waiting lists. So for people that are going to depend on, I know you can't bring collateral sources into negotiations, but I think the reality is that as a special needs planner, I look at it and I go, okay, no matter what it is, we're going to try and make it work. And we're going to bring in as many outside resources through public benefits that we can. And the reality is kind of like the myth of Section 8 benefits, right? People have, I know in the Bay Area of California, there are waiting lists over 20 years long. Wow. So you may qualify, but there's no space, there's no bet, right? And so that may be what we see happening as budgets gets reduced, the level of services. So somebody may qualify medically for the services. They may qualify financially for the services, and there's no one to provide the service and there's no budget.
Right.
There's just endless waiting lists. So being prepared for that and not letting those collateral sources in is going to, again, drive numbers up, because the reality is the services aren't there. Right. So that's what we're seeing kind of happening with this big bill. And we're already kind of seeing the level of services starting to impact our clients.
Really?
the providers aren't out there. And I know a friend of mine at National Care Advisors who is kind of our secret sauce for boots on the ground, hands-on, shepherding applications through, advocating for more hours, things like that. We're already seeing longer waiting lists. And even when you can privately pay for a nurse $75 an hour, $99 an hour for private duty nursing, you can't get anyone, even with the money there. So don't be too quick to settle. Right? Make sure that you've got all your ducks in a row before you do this. So the special needs trust is basically a framework for managing all of these private funds to be able to blend private dollars with public resources to the extent that they're available. And this is where that ticking time bomb is, for God's sake, don't have a family member as the trustee. They're going to want to do it because there's a control issue, right? They want to be in control, but they can't. It's really complicated. So everything that we've talked about today is something that all of these trustees have to know.
I love that you want to help the same clients that we want to help, right? Absolutely. So thank you, Michelle. Thanks for all you do.
Thanks for having me. Really appreciate it. Thanks, Tom.
Thank you for listening to this episode of Lead Counsel Podcast. Your host, Tom Tona. Go anywhere podcasts are distributed. Follow us. Leave us a 10-star review. Share some episodes with your friends. And thanks for listening. I appreciate it. Thank you. This episode is sponsored by TonaLaw. They're not just another law firm. They're defining what it means to fight for their clients. We get a lot of attorney referrals from across the country. We pay fee participation in all jurisdictions where it's permitted. We focus on integrity, innovation, and relentless advocacy. TonaLaw is proving that the business of law can scale without losing its heart. If you want to see how a modern firm is built for impact and happy client referrals, check out TonaLaw.com. Mention again the Lead Counsel Podcast, and I'm happy to get on the phone with you.